Good afternoon, everyone. We are going to wait a minute or two before we start the actual community briefing to allow people time to join us. So if you hear silence, it's not a tech issue. We're just waiting for everyone to have a seat, so to say. So we'll probably start at 12:02. Okay, I think we're going to start now, unless someone flags me that we shouldn't start now. Welcome, everyone. Thank you for joining our community briefing, Advocacy for Unhoused Community Members. My name is Lauren Baker. I'm the legal director at the ACLU of Washington, and I'm going to be your guide, at least through the first part of this. So wanted to thank you for coming on behalf of Seattle-King County Coalition on Housing, the Northwest Justice Project, and the ACLU of Washington. Our three orgs have been collaborating for years around advocacy for unhoused community members and have been talking about potentially putting on an event for a while. And we kind of came to the conclusion that in light of the Supreme Court accepting cert for Johnson versus Grants Pass, and the fact that oral argument happened last week, that now might be a really good time to have the community briefing. And it's not just because of the timing of oral argument, but because what the Supreme Court does in that case could have extensive impact on how we advocate for and protect our unhoused community members. And so wanted to take an opportunity to talk about the case so that people understand what it is and what it potentially could do to protect or not protect our unhoused community members, but then also to talk a little bit more about what we are doing here at the state level, both in litigation and also people who are advocating for our unhoused community members and trying to hold elected officials feet to the fire to protect those folks. And then also wanted to give you some tools for your own advocacy moving forward. And so that's the discussion that all is going to happen today. A few details. There will not be a live Q&A for this event. It turns out over 400 people registered. So a live Q&A was deemed to be not tenable. But we had asked people to ask questions when you registered. And so we went through all the questions that people submitted and we condensed them by themes. And we will try to address almost all of the questions that were posed. So if you don't hear your exact question, it is probably because we altered the wording a little bit or shifted it a little bit to loop with another question to try to hit a theme. And we have a packed agenda today. So let me go over the agenda with you. So the first part of this three-part community discussion will be a legal lay of the land. So we'll have a presentation about Grants Pass, a presentation about Kitcheon versus Seattle ACLU lawsuit, and Skitch versus Burien and Northwest Justice Project lawsuit. We'll also talk a little bit about the state constitution and answer questions that were raised in relationship to these topics. The second part will be on-the-ground perspectives with advocates and providers. So it'll be insight from providers and advocates in King and Kitsap County around what they are seeing people struggle with. And part 3 will be a dialogue on organizing and advocacy. Where do we go from here? What are things that you can do yourself to help protect those who are unhoused? So now we'll move into part 1, the legal lay of the land. And you're going to hear from attorneys from the Northwest Justice Project and the ACLU. And so that you know who it is that you are that's presenting to you, I'm going to actually read their bios so that you know a little bit about them before we dive in. So Fadi Asaf is graduated from Vanderbilt University in 2013, later attended Case Western Reserve University School of Law, received his law degree with honors in health law concentration in 2017. After law school, he worked to advance policy solutions to support affordable housing and equitable development. In 2020, he joined the Northwest Justice Project as a staff attorney focused on consumer and housing law. Scott Crane is an attorney and advocacy coordinator for the Northwest Justice Project. Currently, Scott's work focuses on the rights of low-income people to live in safe and stable housing, free from discrimination. Prior to working as an advocacy coordinator, Scott helped found NJP's Medical Legal Partnership. With MLP, Scott litigated public benefits issues on behalf of Medicaid-eligible children to prevent statewide reductions in TANF, expand autism services, and enhance services for kids with chronic health conditions. Scott also worked as a staff attorney for NJP in rural Washington and was previously a research fellow for the Institute on Race and Poverty. Scott has a JD from the University of Minnesota and a BS in mathematics from Seattle University. Jasmine Clark is the Smart Justice Policy Director at the ACLU of Washington, a role that furthers her dedication to achieving systemic change through sentencing reform, decriminalizing poverty, and combating narratives around crime and substance use that dehumanizes people in the criminal legal system. Sagiv Galai is a newly minted attorney who graduated from the University of Washington School of Law in 2023, so just last year. Sagiv joined the ACLU of Washington's legal department as a legal fellow, where he supports a wide variety of efforts while also focused on combating the criminalization of homelessness in Washington. And as I said before, I'm Laron Baker. I'm the legal director at the ACLU of Washington. So now let's get into the meat of our program. And I'm going to hand it over to Sagiv.
Hi, everyone. Thanks. In order to situate us in this conversation, I'm going to walk us through the broad strokes of Johnson v. Grants Pass, really get us the same page on the essence of this case, and the questions around the constitutionality of laws that criminalize homelessness. To really center us, we need to look at the Grants Pass law first and foremost. Next slide, please. We're here because Grants Pass around 2016 passed this law that criminalized both sleeping outside on sidewalks and alleyways and streets, and it also banned camping outside for unhoused people. I say that this law specifically targeted unhoused people because in the context of Grants Pass's homelessness crisis, these laws were passed to invisibilize their presence on the streets. And the only people who were cited and fined for violating these laws were people who lacked shelter. It's really important to understand in this case that beyond just banning camping outside, Grants Pass went one step further. It decided to criminalize the conduct of protecting yourself from the elements while keeping sleeping bags, tarps, or other bedding on top of you. That was a part of its definition of violating what occupying a campsite was. Next slide, please. Unhoused people in Grants Pass, who amounted to about 600 at the time, didn't take this sitting down. After routinely being cited for a period of about a year, unhoused people got together with Oregon's Law Center and decided to challenge the law as unconstitutional. The argument was that Grants Pass wasn't allowed to criminalize camping and sleeping outside when it lacked adequate shelter. You may be wondering where this principle came from, and to understand that, we have to go back in time just a little bit. To do a flashback to Martin v. Boise, a case I think a lot of you are fairly familiar with. Boise had a similar law to Grants Pass. It was explicitly a criminal offense that made it a misdemeanor to sleep and camp outside. When Boise enforced its law, it only had about 200 shelter beds, but its unhoused population amounted to about 800 to 900. The people who were routinely cited and punished in Boise also challenged that law. And about 10, 11 years later, they came out with a notable victory, one that we keep harping back to nowadays. It's really important for us to be on the same page of this about this constitutional principle that was the victory of Martin v. Boise. I tried to recreate it here for everyone. Boise stands for the idea that when there aren't enough shelter beds in a given jurisdiction, that jurisdiction cannot enforce a camping or sleeping ban. As a result, courts after Martin v. Boise engaged in a sort of formulaic comparison. On the one hand, they evaluated how many shelter beds there were in a given jurisdiction. And on the other hand, they evaluated how many unhoused people there were. And if there was an incongruence, meaning more unhoused people than beds, then the law could not be enforced. On the other hand, if there were more beds than unhoused people, then camping and sleeping outside was a viable law to be enforced against them. Next slide, please. It's also really important as we talk about Johnson v. Grants Pass to understand the shortcomings or the limitations of Martin v. Boise. It is a notable win, one that we should build on. But Martin v. Boise did not address some of the cruelest manifestations of laws that criminalize homelessness. It didn't ban sweeps. And it also, like I said earlier, engaged in this distinction between voluntary and involuntary homelessness by saying that if there are enough beds out there, then people can be arrested, fined, or punished for sleeping outside. The idea of a sufficient shelter capacity triggering the enforcement of laws that ban camping is, in a way, crystallized by Martin v. Boise. Unfortunately, Martin v. Boise also allowed cities to punish people who are obstructing access, meaning blocking the sidewalk or blocking a waterway or sleeping in front of a courthouse. And Martin v. Boise allowed for time and place specific camping bans, like you can't sleep from 6 to 6 on the beach. Fortunately, it didn't go far enough. And cities like Johnson and cities like Grants Pass were able to enforce their law after Martin v. Boise. Next slide, please. Johnson v. Grants Pass was filed about 10 weeks after Martin v. Boise was decided, and it rippled through the federal courts for a while until finally Supreme Court decided to take the case up. Now, at the heart of this case is a general question. Are there constitutional limitations on cities' abilities to criminalize sleeping and camping outside, to criminalize homelessness in its purest manifestation? But because of the constitutional principles implicated by this case, much of the conversation revolved around whether homelessness is a status that can be criminalized. Next slide. This was a vibrant debate in the oral argument, which I'm assuming some of us were able to catch, with the liberals embracing the idea that there is a limit to how far cities can go in addressing this crisis of homelessness. And that limit is criminalizing a status. Justice Kagan posited that maybe we can't criminalize the status of homelessness, and instead the advocates of Grants Pass pushed back and didn't actually want to register the idea that homelessness would be a status like drug addiction, which is currently tenuously, but is protected under the Eighth Amendment from being criminalized. But Justice Kagan retorted simply, homelessness is a status. And she described it to us in really succinct ways. It's the status of not having a home. For her and the other liberals, it would go too far for the Constitution for cities to be able to criminalize not having a home by punishing people for sleeping outside when they didn't have shelter. Unfortunately, There were others on the court who had a much more sinister take. Chief Justice Roberts, an elusive, friendly face, asked us, is being a bank robber a status? I think for a lot of us, this was a fairly heartbreaking question because it assumes a criminal nature to the conduct, comparing people who may be harming others to those who are striving to survive outside to the best of their ability while adequate shelter was lacking. Chief Justice Roberts wanted us to think that this ordinance is about not listening to the cops. That Johnson v. Grants Pass is about not being told not doing what you're told to do by law enforcement. But in effect, and I would say successfully, counsel for the unhoused plaintiffs in Johnson v. Grants Pass argued that violating this ordinance only occurs for unhoused people. This ordinance doesn't attack people who are stargazers or on campgrounds. We know this from the record of the case. The only people who get cited, punished, trespassed, and banned from parks under the law of Grants Pass are people who lacked a home. It's important to walk away from this status conversation, understanding that homelessness is a status. I would disagree, not because it's something that you are, but rather it's a social condition. It's a circumstance that one is thrusted towards, born out as a result of structural inadequacy, like our failure to invest in adequate housing. I'll pass this to my colleague.
Thank you, Sagiv. So, recognizing the threat to the rights imbued by these two landmark cases, we at the ACLU of Washington have developed a strategy to try to preserve the protections of Martin v. Boise in the Washington state constitution, as our state constitution is more protective than its federal counterpart. As part of that strategy, we have built and are presently building cases that include Washington constitutional theories to protect unhoused people from being punished for sleeping outside. And one of the most foundational components of our work related to the criminalization of homelessness is our ongoing case, Kitcheon v. City of Seattle. Next slide, please. So we, along with pro bono co-counsel, filed this case in 2019 on behalf of 3 plaintiffs, and we alleged that the city's sweeps, which were used against 2 of our unhoused plaintiffs, target our most vulnerable neighbors and invades and destroys their homes, tents, and property, resulting in the displacement and criminalization of the unhoused. And our case includes claims under Article 1, Sections 7 and 14 of the Washington State Constitution. Article 1, Section 7 safeguards individual privacy and the sanctity of one's home and establishes the fundamental right to privacy and protection against unauthorized interference in private matters and homes. This constitutional provision ensures that individuals are shielded from unwarranted intrusion into their personal lives and residences. And it underscores the importance of legal authorization when it comes to matters affecting privacy and home security. Article 1, Section 14 pertains to cruel and unusual punishment, and it ensures that individuals are protected from harsh and disproportionate penalties. This constitutional provision safeguards individuals from undue financial burdens, harsh penalties, and inhumane treatment. And it underscores the importance of maintaining a balanced legal system by preventing excessiveness, safeguarding against cruelty, and promoting justice. So in 2023, we won summary judgment in this case, and the King County Superior Court ruled in part that the rules underlying the City of Seattle sweeps policy permit unconstitutional invasion of unhoused Seattle residents' privacy rights without notice, without presenting them with alternative shelter, and without giving them opportunity to protect their property and shelters. The court ruled that unhoused people have privacy rights in their homes protected by Article 1, Section 7 of Washington's Constitution, and explained that denying the plaintiffs any protected privacy in their homes would be yet one more permission slip to consider them not fully human. The court further stated that Washington's Constitution has historically protected home, and that history belongs to the unhoused with as much force as anyone with access to stable housing. And the court also held that the city sweeps policy subjects the unhoused to cruel punishment in some circumstances under Article 1, Section 14, because the sweeps subject them to criminal and civil penalties for living on public land when there is no alternative to do so. And this ruling followed the existing body of law that prohibits a city from enforcing ordinances and rules against unhoused people when there is no other place in the city for them to go. And the court also recognized that the government cannot avoid this prohibition by issuing civil citations, which can result in criminal penalties. The city has appealed that ruling, and the plaintiffs have moved to transfer the case to Washington Supreme Court for determination. And I will pass it to Fatty.
Thanks, Jasmine. Could we possibly get the next slide? All right, so I'm going to briefly present on the Burien ordinance and the lawsuit that the Coalition on Homelessness brought against the city of Burien. Before I start, I just obviously want to thank Sagiv and Jasmine for giving an overview. It makes my job a lot easier, and hopefully I can present some of the touch points here in a less desultory manner. And also I want to briefly note that NJP here is presenting on the Burien litigation, but is not necessarily taking any position on any lobbying or grassroots advocacy. I think we can move a slide ahead. This is sort of an overview of some of the cases that Northwest Justice Project has filed that deals with homelessness in the state of Washington. I want to briefly highlight one of the cases, Potter versus the city of Lacey. That case involves an RV ordinance that basically said that you can't park on non-residential property and you can't park on publicly owned areas between the time of 10 p.m. and 7 a.m. So the ordinance severely limited residents' ability to live in the city of Lacey, which amounts to banishment. The attorneys in the Potter case are currently waiting on the Washington. They provided oral argument in October, and they're currently waiting on the Washington State Supreme Court to provide its holding. So with that, I think we can move to the next slide, please. All right, so the Burien ordinance, there's a lot of history here. And I'll start with just the ordinances that they've passed. They originally passed Ordinance 818 and then amended that with Ordinance 827. We filed after they amended the ordinance the initial time and passed Ordinance 827. More recently, they replaced both of those ordinances with Ordinance 832, which passed on March 24th, 2024. And we can move to the next slide. All right, so after they passed Ordinance 827, they provided the city property notice to individuals that were camping in the city of Burien at the Ambom Boulevard location. And it was their first attempt to try to enforce the ordinance. At that point, many of the individuals that were living at that location relocated to another location, which was a church site that housed them temporarily for 3 months. Currently, the individuals that were at that church site, as well as other individuals that did not camp at the church site, are camping throughout the city of Burien. And I want to kind of briefly talk about what the ordinance does and how we've responded to it. So I think we can move to the next slide. So what Ordinance 832 does is it prohibits an individual from camping during the day. It also prohibits any individual from using non-residential property as living space. I use the word camping just for simplicity's sake, but really camping seems a bit recreational. Really what it is utilizing public space for survival. So it says you can't do that during the day, and you also can't do that at night. The only places, and they've designated certain areas where you can do that, and you can only do it between 7 p.m. and 6 a.m. And the prohibition doesn't necessarily apply if there's no available overnight shelter and a person is camping in a non-prohibited area. And I'll briefly touch on what a non-prohibited area is later and hopefully provide a visual that can help everyone kind of better understand this. Although I will admit it's still a little bit difficult to understand. And they've defined non-residential public property as living space, and it means to camp, dwell, lodge, reside, sleep, or exercise non-transitory exclusive control over any portion of non-residential public property. And I will state here that they left the term non-transitory exclusive control undefined. So we kind of gave the overview, which is that you can't camp during the daytime and you can only camp in certain designated areas at night. So if an individual puts up their tent at night and then is walking around and say puts a stovetop on the ground to try to cook or sits on a park bench, that potentially could be exercising non-transitory exclusive control, which means they would violate Ordinance 832. So I think we can go to the next slide. And just to provide some additional definitions about how they're defining camping, and it kind of mirrors what Sagiv was saying about the Johnson Grants Pass case, Johnson versus Grants Pass, which if you're sitting on the ground with a tarp over you to get some shelter from the elements, or if you have cooking equipment, as I was highlighting a little earlier, that potentially could be a violation of the ordinance. And then briefly to touch on available overnight shelter, and this was also a problem in the Grants versus Grants Pass case, Johnson versus Grants Pass, is that they're considering availability of an ordinance. They're considering availability of a shelter, even if there might be some barriers that would prevent someone from accessing that particular shelter, which is problematic. And a lot of shelters, as we know, have different rules or requirements that individuals may not be able to comply with, or do not want to comply with. And those barriers would prevent them from obviously making use of an available overnight shelter. So I think we can go to the next slide. And this next slide is the prohibited camping areas that I was discussing earlier. And it's quite the visual. It's essentially a map that they posted online, and they gave the city manager exclusive control to change this at any time. And I didn't get into our claims because they mirror a lot of the earlier claims, bringing in claims under Article 1, Section 14 of the Washington State Constitution, which mirrors the excessive fines clause because they're essentially banishing people, bringing a claim under Article 1, Section 7, which Jasmine did a really good job explaining, which is also known as the private affairs guarantee, and then also bringing a due process claim. And part of that is that the city manager has the opportunity to republish this map at any point and say, okay, you're camping at this particular area. Now we're calling this area off limits, and you're going to have to figure out a way to make it work for you. And as you can tell, there's these dark gray areas. Hopefully the legend helps a little bit. There's these dark gray areas. There's green areas, which are public parks, and Burien already outlaws, has had a law in the book for several years that prohibits camping on public parks. And then you've got these light gray areas, and those light gray areas are the only areas that you're allowed to actually camp in the city of Burien. But as I said earlier, during the day, if you're walking around with certain items, or say you work at night and you need to sleep during the day, or you want to just rest on a park bench, that could be seen as exercising exclusive non-transitory control, and that could perhaps amount to a violation of the ordinance. And so we, along with the coalition and 3 plaintiffs in the city of Burien, brought a lawsuit against the city of Burien to question the constitutionality of the ordinance that they passed. In addition to that, after they amended or replaced the ordinance 827 with ordinance 832, the King County Sheriff's Office / King County also filed its own lawsuit because the city of Burien has a police force that's contracted through the King County Sheriff's Office, and it was their responsibility to enforce an ordinance that King County also believes is unconstitutional. So it's a bit of a group effort here to try to challenge an ordinance that we think is truly problematic, and we've seen copycats of this ordinance and other ordinances across the state. And I think one thing to really gain from this is that we all have our own circles. We all kind of do things on our own, which is great, but collectivism and autonomy are not necessarily mutually exclusive. And so we have to find ways to really build on the strengths of each other, and hopefully continue to do that in the future as we figure out an appropriate response to something that is truly problematic for unhoused folks, and I would say any person that cares about this community. So we've dropped some links, hopefully in the chat, some news articles for that cover this lawsuit, as well as King County's lawsuit, a copy of the ordinance, as well as some links to Northwest Justice Project. And if you have any questions or just legal issues in general, one really great website to reference from time to time is WashingtonLawHelp.org. We've got several resources on there for individuals within the state of Washington that may have legal issues that pop up and just are looking for some simple solutions to how to address those issues. So I think with that, I can pass it on to the next speaker, or maybe questions.
Great, thank you so much, Fadi. We wanted to talk a little bit about the Washington state constitutional landscape. I think sometimes people have been concerned that grants pass is really going to have significant impact on our state. We are really hopeful that that is not the case. Our state constitution is really doesn't run in tandem with the federal constitution all the time. And there are certain rights that are just stronger under our Washington state constitution. As Jasmine talked about earlier, the privacy right under Article 1, Section 7 is much stronger than its federal counterpart. And the cruel punishment protection in our Washington state constitution under Article 1, Section 14 is stronger. The language doesn't require cruel and unusual, which the federal does. And so we are really hoping that as these lawsuits make their way up to our state Supreme Court, that we can pull ourselves away from whatever SCOTUS may do with grants pass, and hopefully the courts provide even stronger protections underneath our state constitution. And as Jasmine said earlier, our Kitcheon case, we're waiting to find out whether or not the Supreme Court will take kind of a direct review, and hopefully we'll know in the next little bit if they will, and that might help us get closer to figuring out like what is the scope of protections underneath our Washington state constitution. Scott, did you want to add anything?
Thanks, Laurent. I think Fadi covered it pretty well, and I certainly concur in your analysis. I think we have been looking at the changes at the federal landscape, as ACLU has, and learning from people that we speak to that there's not a lot of solutions out there for folks, and we need to look at what other protections might exist and are looking in the same place as ACLU and many other fronts where we've been trying to figure out how can we best protect folks from threat of arrest or banishment from the homes that they live in.
Excellent, thank you. Now we're on to the last part of this section, which is the questions and answers that were raised when people registered. And we're doing this pretty organically. And so I'm really hoping that everyone weighs in with their thoughts and opinions. The first question is, judges seem to go round and round on homelessness as a choice versus a status, and whether civil versus criminal charges mattered in a case. Can you address this from your perspective?
Happy to jump in. And I'll try to take on the choice versus status if others want to deal with the civil versus criminal, though I have opinions about that too. We spent a lot of time thinking about this at the ACLU of Washington. We've got a couple of exploratory events that have forced us to really contend with the idea between choice and status. And we've met with a lot of people who also helped us just develop better understanding around what it's like to live outside during this sort of crisis of criminalization. And the best way I can communicate this, and in a way, I don't want to be too reductive, but there are a lot of individual factors that make one vulnerable to homelessness. But there is one thing that causes homelessness, and that thing demonstrates that it is not a choice. And that's the absence of affordable housing. You can be immensely vulnerable to homelessness, but that final condition of being unsheltered would not happen in an environment where there was affordable housing. We have those who live in crisis and people who have been pushed out of certain institutions or marked by our mass incarceration crisis and left in a situation where their likelihood of achieving stable housing is compromised, but they would not be unhoused if we had affordable housing. Homelessness is ripe. It is happening in places that have high rents and low vacancy rates. That is the biggest determinator of homelessness. High rents, low vacancy rates.
And I can jump in as to the civil versus criminal charges. I think that that connects well with our Kitcheon case. Understanding that there is overlap between civil and criminal penalties, right? In Kitcheon, the court ruled or recognized that the government cannot avoid the prohibition by issuing civil citations, which can result in criminal penalties, right? If you fail to appear at a hearing for a civil infraction, that can lead and does lead to criminal penalties.
And I guess just to add a little bit, sorry, my phone's coming off. One of the things that about sort of the unavailability and the vacancy rates, especially in certain areas in Washington, where we don't have naturally occurring affordable housing, it makes it especially difficult for individuals to find housing, especially if there's something on their civil record or civil judgment, such as an unlawful detainer action, also known as an eviction, preventing them from accessing housing. And then briefly on the second part, what I particularly look for is anything that's if there's a partially punitive purpose. So just to give you an example, in a vehicle impound context, the vehicle may be impounded for a violation or a safety hazard, but then keeping that person's vehicle in an impound lot for a period of weeks or a period of months has a partially punitive purpose. For a lot of individuals, they're able to take a credit card or stop by an ATM and get the vehicle out of impound. But for individuals that may not have access to financing or the means to get the vehicle out, it very quickly takes a punitive form.
Okay, we'll go on to the next question. The plaintiff's attorneys in the Grants Pass SCOTUS argument said that under their theory of the case, it would be constitutional to prosecute someone who declined shelter because of their behavioral health condition made it a bad match. Thoughts?
I think for me, what I'd like to convey for those who are maybe less familiar with this landscape is that this idea that comes out of Martin v. Boise that distinguishes between voluntary and involuntary homelessness because it supposes that people have a choice to be outside and that they are choosing to by declining shelter. It's a fallacy on various levels, but I think the most harmful one of it is that it creates an illusion around what we're offering people. What we have been offering people doesn't work. What we have offered people has led us, for the most part, to this crisis. We see this in a most pronounced way with our disabled unhoused population. What we have been able to offer them doesn't address the way that they can support each other, the way they show up for one another, the communities they've erected to stay safe and to address their needs. And our shelters are impermanent. That is not a solution for people who need stability. What it does do for our housed population is that it makes homelessness invisible. That is probably the biggest harm that can come out of this idea that people are declining shelter and need to be arrested and forced into services, because we're trying to make our crisis, our communal crisis, invisible.
And I'll just add to something Steve said. When we looked at the Burien ordinance first, it did say if you can't go to a shelter because of issues you've had there before, because of substance abuse, because of behavioral incidents, that shelter was still considered available, and the police were allowed to decide that under that previous ordinance. Like Sagiv said, it rests on a fallacy of assuming that we've actually offered shelter to anybody, and it compounds that fallacy by saying it's still available even if you can't go there. It doesn't recognize, what we're trying to do is actually give people housing, and that's not the solution that's being provided. So I wouldn't say, bad match is not necessarily how I'd phrase it. I'd say it's unusable for somebody because they can't get in. And that's the reality sometimes. So I think, again, that's something that's a concerning development in many of these ordinances, that the availability of shelter can be conditioned on your mental health status. And that just sets up a recipe for disaster for people who are the most vulnerable and homeless.
Okay, folks, we are a little over our time. Does anyone have any last comments that they want to make before we move on to the second part of our presentation? Okay, so the next part 2, on the ground perspectives and advocates and providers, with advocates and providers, is going to be led by Judy Rausch, which I hope I pronounced that correct. She is a senior programs manager for the Seattle-King County Coalition on Homelessness. Jody has been a community public health nurse for 20 years. Prior to joining the coalition, she spent 5 years working with Seattle-King County Public Healthcare for the Homeless Network. Her work has always been situated at the intersection of health, community, and public policy.
Thank you, Lauren. Welcome, folks. I am honored to be facilitating part 2 of this webinar on the ground perspectives with advocates and providers. I do just want to be clear that the information provided in this section reflects the experiences of the presenters. They are not lawyers or legal experts, and this is not intended to be legal advice or an analysis of the law. Our guests today will share with you their understanding and insights into the realities people face when living without a stable home. For many of us, the experience of homelessness is understood through the media's portrayal of what it means to survive without the necessity of a safe place to sleep or access to a toilet or sink. These narratives and images shared in our news feeds and on our TV both sensationalize and generalize the circumstances that may have contributed to an individual or family's experience of living homeless. It doesn't convey the failures of multiple systems that create housing instability, nor does it illustrate how proven solutions lead to stories of safety, stability, and success. Homelessness is as complex and as nuanced as the individuals surviving it, and it's a reality that can be improved by the policies, investments, and decisions that we and elected officials choose to support. So I am pleased to introduce to you 4 dedicated and inspiring providers. Rachel Scott is here. She works for Evergreen Treatment Services REACH program. She is the REACH outreach system coordinator, and works in Seattle throughout the neighborhoods of Soto, Georgetown, West Seattle, White Center, and South Park. She has a background in social work and public health. Kimmy Siebens has been a nurse for nearly 20 years, working mostly in trauma ICU at Harborview in Seattle. She's the founder of the Bremerton Homeless Community Coalition and the nonprofit Their Voice, which is assisting unhoused pet owners, as well as a task force member for the Washington State Physicians for Social Responsibility. Karen Salinas works for Evergreen Treatment Services REACH program as the Director of Outreach. She has a background in public health, working with folks who use drugs and engage in sex trade. And rounding out our panel is Dawn Shepard. Her works for Evergreen Treatment Services REACH program. She is the South Lead Recovery Navigator Program Manager. She has years of experience in direct outreach and works to help create an effective system response that is coordinated across multiple entities. So we're going to start with Rachel. You work with people who fit the definition of being chronically homeless, have substance use disorder, and high behavioral health needs. What are you seeing and experiencing on the ground as you do your work?
Hi, thanks for having us. Yeah, so I'm going to talk about some barriers and stressors and also some more positive like strengths we're seeing. And I'm sharing all this in the context of, these are things that will likely not be fixed by further criminalizing homelessness. So in terms of shelter, let's talk about shelter because it is something that comes up in a lot of these conversations. We don't want to get too into the weeds, but briefly, like there just is a lack of shelter beds. We often, as outreach workers, pose shelter as a possible step towards seeking permanent housing. Some of the shelters provide housing navigation, but getting into those shelters is very challenging. And one of the ways that the shelter system referral system works in Seattle is that the city's unified care team has priority access to many of what people consider like the best options. Those are usually spaces with a door that locks and has a semblance of privacy. So sometimes these are tiny house villages or other similar setups. And those are often set aside for people who are being displaced by city removals, which maybe, in and of itself is like a good thing, but it doesn't leave many options for other people across the city who are asking for shelter and aren't able to be prioritized. And so that's also to say nothing about the people outside of Seattle. As Seattle workers, we aren't really supposed to refer people from like unincorporated White Center, Burien, South King County through the unified care team referral process. Standing up those resources and shelters in those other jurisdictions requires both political will and money. And that's just something we're seeing a lack of in some of these other smaller areas. And a lot of places, we hear if you build it, they will come. And I think that stresses and scares some cities. They don't want to build shelters for that reason. So to be clear, there's only like a few beds available per day versus the hundreds and hundreds of people that outreach workers are seeing across the county. And then there's unequitable access for people to access those shelters. We do hear from clients who are referred to shelter, but they're often turned away because they show up with the pet, or the shelter doesn't have their name on the list of approved people. There's a lot of logistical things that get in the way, a lot of barriers. And then, we ask people why they don't want to go to congregate shelters, which are like spaces where people don't have a lock on the door. They report that it's loud and chaotic, their stuff gets stolen, there's no privacy, they can't bring their pets or partners. And, you also are just getting a lot of people together who have their own behavioral health challenges. And the spots are often like understaffed and the workers aren't paid appropriately and there's not sufficient training a lot of the time. Everyone's, trying to do the best they can with the resources they're given, but these resources are minimal. And then we hear from women's shelters like Wheel in Seattle that are completely maxed out, overflowing every night and having to turn people away, which is something that they've like historically rarely ever had to do. Also during the day, lack of day centers, places to engage with resources, shower, hygiene, laundry. The no camping legislation in Burien, for example, if you can't be seen outside with camping paraphernalia. And we know this isn't being enforced in Burien currently due to some disagreements between law enforcement and the city management. But it does illustrate that people don't have a lot of options about where they can just be during the day. And if enforcement of these bans becomes enforceable, it leaves a lot of questions about where people can exist in public. We've also got the whack-a-mole problem, something we see consistently. We hear from businesses and community members, encampments are removed, but people aren't necessarily offered legitimate alternatives. So they just pop up down the block or repopulate the encampment a week later. People have been moving block to block in places like Soto and other neighborhoods for years and years without good offers of housing. These like removals could be opportunities to connect folks with more stable housing situations, but really that's just not happening. people on the street, they want to engage in services. They want places like designated parking areas or housing. There's just limited supply of intensive case management and services and places to navigate to. We do see that when encampment resolutions are coupled with intensive outreach and permanent housing placement, we see much more success. For example, the ROW or Right-of-Way Initiative, which is a joint project between Washington State Department of Transportation and several homeless service agencies to move people from properties alongside the highways directly into permanent housing. We see better long-term outcomes with these types of initiatives, but those, require political buy-in and funding to make these things happen. I know we're got to wrap up for time, but, we also see concerning toxic drug supply, lots of overdoses and unknown substances and quantities. We are seeing increased access to low barrier methadone and buprenorphine for individuals interested in that path, however. And then one thing that's really come up recently, and we're hearing from clients, is increased vigilantism towards unhoused people, gasoline thrown on tents, people throwing eggs, harassment, violence. People are really feeling that hostility and hate towards them. It's further ostracizing them, marginalizing them, and it makes it more difficult to integrate or try to get them back into engage in services. The sentiments can be inspired by inflammatory or dehumanizing language in the media, as well as misinformation propagated by elected officials. We're hearing a lot from our clients that they're feeling this heat. If community members think individuals are refusing services rather than just understanding these extreme barriers getting in the way, then they become hostile and want to retaliate against our unhoused neighbors. I also just want to highlight the positives people in encampments are looking out for each other. They keep each other safe. Individuals and groups are carrying Narcan and identifying themselves as I'm the keeper of the Narcan, reach out to me, I've got your back. People are trying to sign up for purple bag programs in Seattle, which is garbage pickup to keep their area clean and minimize community disruption. Lots of requests for navigating the housing system. And we are also building, as outreach workers, building relationships with communities and talking to businesses. We often hear from disgruntled business worker or business owners, but there's also people who recognize that the current processes aren't working and want to see real investment in solutions, not just criminalization without those practical solutions. And, probably short on time, but there's also all the stuff about what's going on in Burien and no shelters. And, but I'll just keep it at that because I know we've got some other questions.
Thank you, Rachel. It is, that's a wealth of information, and I really appreciate you speaking to some common myths that surround homelessness and the experiences of people, such as it's not an often known fact that people experiencing homelessness are more likely to be the victim of criminalization and not perpetuating it, and highlighting projects that are currently underway and have had great success, like the state right-of-way and the investments needed to make that happen. So thank you for being here. Kimmy, I want to turn to you next. I want to ask you the same question. What are you and your clients seeing and experiencing on the ground since Bremerton passed an ordinance related to unauthorized camping?
All right, thank you so much. So this past summer, the city where I live in Bremerton implemented an ordinance which updated the municipal code that's called unauthorized camping. And that states that when a shelter bed is available, it's unlawful for any person to camp in a park or other public place. The city council said the purpose of the ordinance was to align our city code with the Martin versus Boise federal court ruling. And they presented it as a really positive step, stating that it would better clarify the code using the time and place restrictions. However, in my recent experience, this ordinance unfairly targets unhoused individuals and appears to create even less places where an unhoused person can exist. So even if a person is banned from a shelter due to behavioral issues, or their pet, their dog or cat has a behavioral issue, they can still be affected by this ordinance and face penalties like citations, misdemeanors, which we know can lead to felonies or, God forbid, even jail time. The same goes for all the folks banned from shelters due to medical conditions that a lot of people don't talk about, but incontinence. I see this affecting the older people who can no longer take care of themselves and change their diapers. And the shelter is just not a place to provide nursing care, or it isn't yet. Maybe it should be someday if we're gonna, not provide housing. Hospitals will tell me that the person doesn't meet criteria for them to admit the patient because their needs aren't that high yet until they're sometimes near death, and then I can take them to the hospital. And it's also very challenging to find a placement in adult family homes or assisted living or nursing homes, which I've done multiple times. But I have to use the assistance of the court and other professionals that these folks don't have access to or the wherewithal to know where to go. Shelters are really heavily relied upon, but they're not equipped to provide the level of care needed for every single person. And so one way to help shelters is to offer services that they cannot. This is talking from me, a very small scale nonprofit. So these are services that are desperately needed, but may not align with the shelters, their mission or their goals. So my own nonprofit called Their Voice has provided pet food, pet supplies, spay and neuter, vaccinations. Some of that helps them get into housing later on as well. And when we can, urgently needed vet care. Also, we've provided funding for people to receive training with their pet in hopes that the improved behavior will help them enter a pet-friendly shelter and be able to continue staying there. There's a lot of confusion out there about the new law, and I have seen different officers interpret it differently in the field. The ordinance has a lot of details and certain languages used that appears to make like even more public space off limits. It lists almost every possible space where sitting with like a sleeping bag is not allowed. And we just want to know where people that have no place to go can go other than out of town. Even though the ordinance states that people with disabilities that prevent them from staying in a shelter are exempt, it says, I have personally witnessed cases where individuals with obvious disabilities such as autism and deafness who had disruptive, loud behavior and a lot of difficulty following basic instructions, they were still told by the police to move along. Generally, until I start live streaming, then things seem to cease happening on my social media platforms. I've been told that just because the person at question, or if I say the person is disabled and not eligible for a certain shelter because I know they're not, that it will actually be up to the city attorney to make the final decision about the person's disability status. I'm not sure if the attorney knows about that. I have been told by officers that a shelter will accept a person. And then when that person is taken there and I go to follow up, they're not allowed in because we already told them they're not allowed there. This is futile. They're losing all their stuff. I have to buy them new stuff every time. It's just futile. The approach doesn't seem fair. It doesn't seem sustainable in determining like someone's disability status. And it's all super confusing. Also, depending on what institution you look at for guidance on disability, the loss of bladder or bowel control can be considered a disability just as well as substance use disorder can. And laws on emotional support animals and service animals can get even more challenging to understand, yet rarely things are challenged when they're like wrongfully administered to unhoused people than their pets. And then also after, not before, but after this ordinance passed this summer, the police department hired this Seattle-based, it's like a right-of-way firm for a few $100,000 a year to do what they consider outreach to unhoused people. And I'm super confused about what this firm can offer that local service providers like myself haven't. And unless the firm can build like affordable housing or increase wages around our town that can actually provide a livable wage for all classes of people, then I don't know what they can do to actually solve and not just hide this issue a lot better. And there's not enough homes for people to live in. There aren't enough medical detox facilities or mental health facilities in the entire state. There's not enough jobs that can actually pay the bills. I also see patient dumping at the local shelters as well. Shelters do not receive enough support from government or local medical facilities, who I've witnessed for many, many years, dropping off very medically complex and unwell people at the shelter's back door. And it seems like the shelters are expected to do what nobody else is willing to do. The shelters, they seem to accept the fact, and I don't see a lot of pushback or holding the medical facility responsible for the inappropriateness of the transfer. However, working as a nurse for so long, I understand it's very daunting to try and take on a huge corporation like the hospitals. I've done that before, and it's not simple or easy. And generally, nothing really comes of it, except for what they say is a slap on the wrist and a lot of money payout. So overall, what I have observed is a huge effort to relocate folks from my jurisdiction and shift the responsibility onto another area, maybe yours. You can start meeting some of my Kitsap County people here soon. And from my point of view, this totally just prolongs the state of survival for all these folks, and it causes a lot of trauma unnecessarily in all of their lives.
Thank you, Kimmy. I really appreciate you highlighting the medical complexity of a lot of folks that are living homeless. I know a most recent point in time count here in King County noted 51% of people experiencing homelessness are living with a disability. And I think you really highlighted the fact that the current homelessness crisis system, in particular shelters, are not equipped to navigate folks' complex needs. And I think what really rung in my ear is, where can people go? You asked that question, where can people go? And be able to stay in the community that they call home. So thank you so much for being here and sharing your experiences. Karen, I'd like to turn it over to you next. And in addition to housing, what are the greatest needs of the unhoused folks that you serve? And what do you as a service provider need to support them when you're working with them?
Cool. Got my two answers put together. I think just highlighting what Rachel and Kimmy, talked about, it's the gaps. Homelessness is a creation of all the gaps in our systems that have not been set up to adequately serve the different kinds of people in our population, like the mental health, the complexity of mental health care that is needed, that is not paid for by a majority of our contracts or insurance, the complexity of medical issues, the disability needs that they have, that we're trying to GoFundMe a way to get someone a wheelchair oftentimes, or seeking extra ways to get necessary life supports for people. I think really having those wraparound harm reduction, outreach-based services is necessary for folks who are homeless, who, because of the years of trauma they've experienced in these systems, are not going to just willingly walk in through the door. There needs to be that engagement and support, rapport building, and orientation to different spaces, to different systems, to different ways to navigate, because historically their experience with these systems has been one of punishment and judgment. And so they don't feel confident asking for what they need or knowing where to start to identify what it is that they need to get themselves out of the situation that they're currently in. Another need for the population is time. It's just the understanding that these complex issues took years or decades to get to this point, and it might take years or weeks to change those behaviors that have been created as a part of learning to survive outside on the streets in a completely different world than people who are housed, than the society and the structure that we live in. And so reintegrating back into being outside can be really hard, and being able to give people that time that they need. And I think that that goes along with privacy, especially with these bans going into place. It's a respect for our health and human right to privacy that oftentimes we as outreach workers only have the ability to provide services outside because there's nowhere to take them. They're banned outrightly often. They need to carry all their stuff with them. So meeting them at the place they're staying is the best way to work with them on their documentation and stuff. And just as a community, having an understanding that while they are visible to the community, it does not give you or entitle you to knowing everything about them or to impose yourself in their private space, especially when they're working with their outreach worker. Similar to what Rachel was alluding to, there have been neighbors going up to our staff and just trying to get involved in the meeting as we're trying to have private health conversations with people. I think this is also necessary for where our community is at when we talk about community care. There needs to be roles and boundaries in that. It's not just like open for all, because then that could lead into the violation of an individual's right to their own health care and to being able to access their own health care. I think that that's also where trauma-informed substance use counseling and having spaces where people can use safely or hygienically and then get connected to those long-term intensive resources is really necessary. Then to speak to what do we as service providers need, I think what Rachel and Kimmy were talking about, which is the overall system of us as service providers. What does that look like? Many times working in the nonprofit space, we don't have the best health insurance. We don't have family health insurance. Those are really critical pieces to retaining staff that have experience, that are able to stay in this work long term, to continue doing that work with our clients. But if we have a turnaround of 3 to 5 years, we have a whole new workforce because they can't stay in these positions because they need to provide for their families, provide for their own medical needs and stuff like that. We're always starting again, training people, and then finally they're at a place where they know how to work with people, because it does take time and experience to be skilled enough to stay in this space long term with our clientele, especially the most vulnerable and with the highest mental health needs. So just thinking about our workforce as a whole thing and the different layers, where often shelters have the lowest wages, yet that's the entry point into accessing housing or being ready for that next step. So if you're burned at that entry point, how are you going to continue with the rest of the system, which is, if not harder, but just as much as a struggle? So thinking about all of those elements, how they play in together. And then my last point will be about intentional coordination with city and community partners and the communication that goes out, being very intentional with what is shared to who and how that's going to work towards the collective goal of serving our community, not just to, satisfy just one stakeholder who has the loudest voice, but to actually create a community that provides the things that everybody needs at different stages in life. Like I think in some situations with the city of Seattle, being more intentional with the coordination, being intentional with the communication that's going out to the surrounding people in the space, the businesses, the neighbors, to not overshare people's private information, but say, this is the process we're going on. These are the boundaries we're going to hold. This is the end result that we're hoping to get. And this is the time, whether it's months or weeks, to get to that point that it will take. And getting that community buy-in to understand that there are frustrations in the community that are valid, but it will take all of us together to reach that goal. And I think that that'll come through effective boundaries and clear communication about what's available, what's going to happen, and then what we're hoping to get to after this.
Thank you, Karen. Really appreciate that idea of community care and how it's going to take all of us as a collective to create the resources that people need. And I think I'm also just hanging on the idea that speaking for myself, but I imagine many folks on this webinar might resonate with, is as a person that has housing, I get to have those private conversations, not out on the sidewalk in the elements. So thank you for sharing that insight. Dawn, we are going to wrap up this section with you. We've got a handful of minutes left, but what would you like the folks on the webinar to know about the work that you do with either the system or the folks that are you're working with?
All right, Jody, you know me. What is a handful?
I want to say like 5 at the most.
Okay. All right. So zooming out, I totally thought of almost every single one of the points that were mentioned by my colleagues that have already spoken. So was doing some last minute brainstorming, trying to figure out what I could contribute to this conversation that is different than what's already been talked about. I assume that there are probably a lot of people that are attending this right now coming from either side of the aisle. I certainly hope there are people who have come here to educate themselves, to get a better grasp of the information regarding the facts, so that they can make the most informed decisions. And that being the case, I just want to zoom out and acknowledge that while the social workers and the service providers may be zeroed in on the needs of our clients, providing for them, advocating for them, and making a way for them to survive and to thrive and to make progression towards housing or whatever their other goals are, that does not mean that I personally don't fully respect the needs and the motivations and the concerns that every other person that is attending this webinar today actually has. I think that businesses deserve to be able to do their best to survive and sell products. And if people who are living unsheltered are challenging that, I think that's a legitimate concern that people have. It's not the reason I'm here today, but if it's the reason that you're here today or any number of other reasons, I would say to you that if we zoom out far enough, our goal is the same. My intention when I'm trying to provide services to our clients is to give them a place to live that is warm, that is safe, that is protected, that provides dignity to them, that helps them to stabilize in all of the ways that are impossible to do when you're living outside. And that's the final deliverable that I hear all the time. I hear not only do community members say, well, I'm told that they don't want housing, that they're offered housing at every single sweep and everyone denies housing and they want to be outside. That is one of the biggest forms of misinformation that we run into every single day. We even run into it by folks who actually think that there are allies because the term has been interchanged with what they are actually being offered. So Rachel, a couple other folks talked about the matching of needs to the individual. And having lived outside unsheltered for 4 years, I can tell you 100% that no one wants to live outside. No one wants to be in the freezing cold. Nobody wants to get soaking wet. Nobody wants to be unwanted where they are. That is a misnomer that I hope I can just shatter right now by telling you that 4 years of living outside and another 10 years of living in incarceration with other people who live outside, there literally is no room for like that's 100% a lie. It's just not the truth. If we can provide people with an opportunity to go inside under conditions that feel safe to them, that provide autonomy, dignity, recognition of their humanity, safety, and individual rights, every single person would go inside. Rachel did an amazing job covering most of the most prominent reasons why congregate setting shelters don't work. They don't work. I preferred to live outside in a tent before going into a shelter setting where all of my belongings were going to be stolen the minute I went to the bathroom, and where my own mental health challenges that were really acute at the time were surrounded by everyone else's mental health acute challenges, right? Like that is just more than we can ask of people. What is working right now is intensive case management programs. We have a number of different programs that have been funded sporadically and on smaller scales that a lot of people don't see. And one of the reasons you don't get the opportunity to see that success is because, well, the news doesn't really report on the successes. The news reports on the things that aren't working. But there is evidence-based studies that are long enough now to show that the LEAD program, which is originally the law enforcement assisted diversion program, started here in Seattle, which now has expanded across the country and into other countries throughout the rest of the world, is a model that has proven itself long-term to reduce recidivism by roughly 58%, to increase legal income by like 1.4% to reduce the amount of time that people actually are booked into jail by like 88%. These are long-term programs and they require a lot of effort because the big end result, which everyone wants to see, is people not living on their sidewalks, creating a bunch of garbage and potentially causing fear to the community or danger to their children. And I understand why that's legit, but the investment on the front end of intensive case management programs is so much cheaper than the cost on the back end for all of our clients who use the emergency room at $1,200 to $1,300 an average pop, and the $165 a day that it costs for us to incarcerate people, which is, by the way, around $60,000 a year.
And Dawn, I'm going to interrupt and just have you just wrap up a little bit here.
Okay. So I guess what I'm saying is that there are a lot of costs that I hear people in the community when I ask with curiosity and an open mind, what is your motivation and what is it that you care about the most that is driving your desire to be involved in this? And basically, a lot of us are affected by money. I mean, most of us don't just have so much to spare that, you know, we can throw it around. It's not enough for people to use their voice, to contact the mayor, to contact their city council. We need to use our voice to let our elected officials know how we want our response to homelessness to be provided. We can clearly see outside, we've been doing these sweeps, we've been doing the same thing for a very long time. We've been incarcerating people. It's just going over and over and over through the criminal justice system, and those things are not working. It's time that our community starts telling our lawmakers exactly what we do need, and that is funding for long-term case management services for individuals, which I realize is more expensive than people want to make as an investment on the front end.
This is actually a really perfect intro into our third part here.
Okay.
I want to thank you, Dawn, Kimmy, Karen, Rachel, for sharing your incredible insight and expertise. And on that note, I'm going to hand it over to Allison to just continue this conversation that Dawn started for us. So Allison, take it away.
Thank you.
Thank you so much, Jody. And I'll introduce myself. I'm Allison Eisinger. I am the director of the Seattle-King County Coalition on Homelessness. I think we have a slide for this, which is part 3 of the webinar, which we called Where Do We Go From Here? Organizing and Advocacy. And Dawn, thank you for making the point that part of what we need to do with our advocacy is to talk about what we want our public dollars to be invested in, and housing is always affordable homes at the top of that list. But we also really want to take the opportunity to look at several questions that people who registered for this briefing shared with us. How can a person who's unhoused register to vote? We're going to cover that. How can we do this work when some elected officials actively want to run unhoused folks out? And what local and state advocacy is planned in light of a bad SCOTUS decision? How do we push back? Well, you've just heard from smart and excellent people, lawyers, social workers, nurses, folks who do outreach, who collectively have decades of experience, insight, and wisdom. Many of those 250 plus people who joined us today do related work either for your jobs or in your personal capacity as volunteers, as part of a mutual aid group. Some of you work inside local government. And we want to acknowledge that and recognize and thank you. The Coalition on Homelessness, and I think we're ready for the next slide here. The Coalition on Homelessness, we don't work in the courthouse. We don't provide housing. We don't provide direct services. We exist to mobilize our community to challenge systemic causes of homelessness and advocate for housing justice. we were inspired, as Laurent started off today saying, to organize this session today with our partners so that we can learn together, so that we can share what we know, and so that together we can push back against cruel and inhumane laws and ineffective policies and advocate for the affordable homes, quality healthcare, shelter, and other services that people need. And the tool that we use to do that is advocacy. Advocacy is a necessary and effective tool. My pro tip to everybody today is advocacy works. The way advocacy works is when people take action, and most specifically, when we take action together collectively. So to the question that was posed, how can we do this work when there are elected officials who actively want to run unhoused folks out? The 4 people we just heard from are caught in that horrendous situation all the time, as are the thousands of our neighbors experiencing homelessness who are being persecuted in many cases simply for existing in their home communities. How do all of us keep doing this work in the face of intensifying extremism, increased inequality, a critical lack of affordable homes, and bad public policies? We organize, we advocate. How are we going to push back and develop local and statewide strategies, even as we anticipate a bad SCOTUS decision? I have news for you. You are part of the answer to that question. You are how we push back, and the answer is not only you, but all of us. This is part of the ongoing work right now. At the Coalition, we're involved in conversation with allied organizations and with state lawmakers to assess what legislative, policy, and budget actions we are going to attempt to advance in the next session. And obviously, we can't wait until the January legislative session. I'm going to attempt in this section to quickly offer you all some resources, opportunities to volunteer and connect, and even invite you to take action right now here today, because at the Coalition, that's how we roll. And when you have 200 or so people on a call, you're going to be invited to take action. I also hope that along the way, you're going to find some strength, some inspiration, opportunities to collaborate, and some validation in this whole briefing. We are in this together, and we know we have to be in this for the long haul. So we're going to tackle the question of voting rights next. The next slide is really about understanding what the resources are in our community. As of January 1st, 2022, people with felony convictions in Washington state can vote as soon as they are released from DOC supervision, from DOC custody, excuse me. How did that come to be? Because of advocacy. In Washington state, you can register to vote using the same voter registration form as anyone else, whether you are currently experiencing homelessness or you're unstably housed. We have information that I think is going to be shared in the chat about our voting rights guide for folks experiencing homelessness or housing instability, as well as information from the folks at Free the Vote Washington, the Washington Voting Rights Restoration Coalition, who work to expand voting rights all across our state. If you're interested in volunteering and you're here in King County, you can sign up to volunteer with the Coalition on Homelessness. We've got 2 trainings for our voting rights volunteers coming up June 4th and June 8th. And we deploy our trained volunteers who are nonpartisan to go to community locations all around King County. When we send you a follow-up email, we're going to assess the extent to which we might invite you to an online opportunity to get some of that information and use it wherever in Washington state you are. We're also going to talk a little bit about advocacy. So that is the next slide. Advocacy, to quote the great Nancy Amadei, advocacy just means speaking up. The thing is, no one gets a free pass. You have to figure out what it is that you can and will do and do it. It's a lot more fun if you can invite others to join with you. So here are just some very basic tips for using your most powerful advocacy tool, your voice. Get to know who represents you at every level of government. In our Homelessness Advocacy 101 workshops, we can help you figure that out. There are lots of resources online. You need to become a frequent correspondent and remind your elected officials at the city, county, state, and federal level that you're a registered voter if you are, that you're a constituent, and that you want to see your tax dollars deployed in effective ways that help people and house them. Get on some good action alert lists. We're going to offer you humbly the Coalition's action alert list and the ACLU of Washington's action alert list. By no means are we the only ones out there. We warmly recommend to you many other organizations, including Poverty Action and the Washington Low Income Housing Alliance, that do excellent statewide work across Washington state and that need folks, especially in rural parts of our state and suburban parts of our state, to speak up. We're going to give you a chance to take action right now. The National Low Income Housing Coalition has a live action alert to tell Congress to invest in affordable homes. We all see what happens when folks get access to a safe, stable place of their own with a door that they can close and bathroom they can use whenever they need to. We are going to put the link in the chat and we invite you to take action using it. And then the last point is to get good information and share it. Washington Law Help is a great resource. I want to specifically point out that the Northwest Justice Project is working on a series of Know Your Rights brochures. And there are a couple that are online right now for folks who live in their vehicles. One is called Living in My Car, Do I Have Any Rights? And another is called They Towed My Car, What Do I Do? Coming soon is a Know Your Rights piece of work about encampment suites and disability accommodations. We'll be sure to send all that information out to you in a follow-up email. And then the last slide is something that we can all do and we can find ways to do it. And that is to show up in solidarity. Tomorrow is May 1st, May Day, and the Women in Black and WHEEL, Women's Homeless Empowerment and Equality League, is hosting a special May Day vigil in Burien in front of the City Hall and the Public Library. They're going to pay their respects to the 11 people in Burien who have died in recent weeks and months. And they're going to call in the community to stand with and for the homeless community in Burien and for folks to get what they need. The Women in Black is inviting everyone to join them from 5 to 6 p.m. tomorrow at Burien City Hall and the Public Library. So with that, I'm going to bring us to a very brief close. I'm going to invite Scott Crane from Northwest Justice Project and LaRon Baker from the ACLU of Washington to share some of their closing thoughts about what comes next. I've already told you that you are part of what comes next, and so we will look forward, we hope, to being in good communication with those of you who attended today in taking the next steps together. LaRon and Scott, thank you very much for sharing your closing thoughts with us.
Of course, of course. And thank you all, everyone who has shown up to this event and everyone who participated. It's really, it's inspiring to see so many who are really wanting to advocate for our unhoused community members. All I have to say in this quick 2 minutes that are left is that, we will continue, regardless of what SCOTUS does, we will continue to try to build protections for our unhoused community members through our Washington State Constitution, and that work will continue. Scott?
Thanks, LaRon, and thanks, Allison, and everybody at the Coalition, Jody, and to my colleague, Fatty, and everybody at the ACLU for presenting. I learned a lot too, and that's always good. I think whatever we've been used to for the last 6 years in terms of restraint, in terms of respecting the rights of unhoused people that's come from cities and other jurisdictions could evaporate by the end of June of this year, putting us into an entirely new landscape where people can be forced out of their communities with no consequences whatsoever. So it's on us to be vigilant, to understand what's going on. And NJP is a resource for folks who are seeking legal assistance. As Allison pointed out, Washington Law Help, but more importantly, making sure folks are connected about their rights and seek legal advice when they are not being treated with the humanity they deserve and the ability to shelter themselves safely and securely. So I think we are hopeful that rights will be protected, but we're watchful in case they're not. And I would encourage everybody to reach out to us, look at our website and see what else information you can get there. Or if there's information that you think we should be providing that we're not, reach out and let us know. We look forward to hearing from you.